Hi, this is Dr. Cora Stack here. I have a grave concern following a letter I got from the Supreme Court today, and I felt a real sting. And I've now kind of figured it out, and it's very disturbing, very, very disturbing. But anyway, this is why I greatly distressed as a result of what was done here. But let me try and explain it in a way why one would be very disturbed. Well, would feel very, very poorly and dismissively treated, and it felt like gaslighting. Why treating distinct constitutional tests as similar matters. Today, Supreme Court declined to examine a cumulative constitutional framework on the basis that it was said to be similar to earlier arguments relying on Article 28 and limited reliance on Article 20, 12.4. And I am not 100% clear about this, but I do know the articles that I relied upon to make education or to make a determination on the alleged constitutionality of the nomination was distinctly different from Articles 12 and from these articles, distinctly different. And I'll explain how I felt mine raised the threshold much higher. And let's just look at this analytically and statistically and probability and see where I would have had major concerns about the adjournment made today on the basis that the first question was similar, inverted commas, to the second question. It is not similar. That's incorrect. So this is a major issue here where one could genuinely feel that one was being gaslighted. It sets out the critical distinction between Article 28 based analysis, which tests executive conduct under a high and narrow breach threshold, Article 28 with limited Article 12.4 as a case study, which remains institution focused, and cumulative analysis under Articles 12, 1/6 and laterally 34, which asks a fundamentally different question: whether constitutional democracy is functioning in practice end to end. Drawing on probability and statistical reasoning and constitutional structure, this video shows why these frameworks are not similar and why they answer different legal questions, and why treating them as interchangeable prevents examination of systemic constitutional failure altogether, allegedly. This is not a comment on outcomes, it's an explanation of method and why method matters. Why treating these nominations questions as the same, which is what I received back in this adjournment, is a very serious error. The court framed today's refusal almost entirely around a question of nomination, or adjournment around a question of nomination. But essentially it was a refusal in the sense of it was going to rely on a nomination question being asked under a different set of articles, which could have resulted in a completely different decision on threshold, and then imported it and then dismissed mine, which was relying on a completely different set of articles, which would have pushed the threshold up. But critically, it did not specify which constitutional articles were being relied upon in each case. That omission matters because nomination defects do not carry a single uniform constitutional threshold. The threshold depends entirely on which articles are engaged. The first framework, nomination v. 28, Article 28 or 28 plus Article 12.4. The first case, by the court's own indication, as I understand it, relies primarily on Article 28 with some reliance on Article 12.4. Now, I'm not 100% clear on that, but certainly 28 comes into it in a major way. Under that framework, the question is, has the executive or the formal nomination process malfunctioned so severely that it crosses a high constitutional bar? This is a procedural and executive-focused inquiry. The breach threshold in this particular circumstances is intentionally high, many democratic harms will not register at all under this lens. My framework, on the other hand, nomination v Articles 12, 1, 6 and latterly 34, my question relied on a fundamentally different constitutional structure. It did not ask whether the executive behaved improperly in making a nomination. It asked whether nomination defects taken together with their effects. It asks whether nomination defects taken together with their effects undermining meaningful democratic participation, Article 12, popular sovereignty, Article 1, the democratic exercise of state power, Article 6, and latterly, and the ability to challenge and correct failure, Article 34. This is not a procedural test, it's a system function test. Why saying these are the same is not just wrong, it potentially changes the outcome. Treating these two questions as the same has a specific effect. It imports the highest and narrowest breach threshold, the Article 28 plus threshold, into a case that was never framed primarily under 28 at all. In practical terms, it means if the executive-focused threshold is not met, then the system-level question is never examined. This is not comparison, this is substitution. Why this mattered for threshold determination? A nomination defect assessed under, say, just Article 28 asked, did one institution overstep? A nomination defect assessed under Articles 12, 1, 6 and 34 asked, is constitutional democracy functioning in practice when participation, sovereignty, power and remedy are considered together? These questions do not share the same articles, the same evidential logic, the same breach threshold, or the same constitutional purpose. Now, most people would simply not know about the high threshold bar involving a 28 application there. Most people would not know that. So that is, most people wouldn't know that the bar using 28 for threshold determination is exceptionally high. This would be known obviously to experts in constitutional law, but certainly not to litigants in person. So I did not. Mine was 12, 1, 6. I may have used 28 in a very small way and 34, but mine was mainly so mine was a much better choice of articles. But I didn't even know that the 28 could have excluded me from a threshold. But I could see now how a decision to focus on 28 could undermine and could close down the whole case very quickly. And then my case, my nomination question would be, well, it's the same. No, it's completely different. Because that was the implication I got today in the adjournment, that it was the same question. It wasn't completely. It completely was not the same question. These questions, because they do not share the same articles, the same evidential logic, the same breach threshold, or the same constitutional purpose, concluding that failure under the first automatically resolves a second is a categorical error. Concluding that failure under the first automatically resolves the second is a category error. Let me say that again. These questions, so let me just go back. A nomination defect assessed under Articles 12, 1, 6 and 34 asked, is constitutional democracy functioning in practice when participation, sovereignty, power and remedy are considered together? These questions do not share the same articles, the same evidential logic, the same breach threshold, or the same constitutional purpose. Concluding that failure under the first automatically resolves the second. Concluding that failure under the first automatically resolves the second is a category error. The critical point, and this is the heart of it, I was not advancing a weaker version of the first article. I was advancing a stronger and broader constitutional test. I was not advancing a weaker version of the first argument, quite the contrary. And unbeknownst to myself now that I've investigated the threshold for 28, involving a 28 application, which most lay litigants would be completely unaware of, I was advancing a stronger and broader constitutional test, just based on my, just examination of just based on my own analysis of the Constitution. By characterising the questions as similar without identifying the articles relied upon, the court effectively avoided examining the framework with the greatest capacity to reveal systemic breach. This is why this matters. So where a court treats distinct constitutional frameworks as the same without identifying the articles relied upon, it risks applying the narrowest and highest breach threshold to questions that were never framed that way. In this case, an executive focused nomination test could be substitute for a cumulative democratic one. The result then would not be a finding that the threshold was unmet, but a refusal to examine whether the correct threshold applied at all. So I'm not alleging intent, I'm not questioning legitimacy, and I'm not, I'm demonstrating analytical displacement, and I'm showing why the outcome could be structurally predetermined. And I'm making the strongest possible case that my framework, in fact, would, if I hadn't done this video, be never actually examined. So this is very, very serious. Very, very serious. And I got a sting today when I got this, and I knew, I knew there was something majorly. There was a major signal in this, and this is what, unfortunately, this is what has come out of it. It is extremely disappointing, very disappointing, very, very disappointing and disheartening. And I hope now that the court will respond, in a proper way here. And it is staggering in the extreme that that I felt gaslighted hugely, and when I feel gaslighted, it means somebody is, there's something going on here which is allegedly suspicious, of a suspicious nature, or of a manipulative nature, or an underhand nature, and it's deeply, deeply disturbing, not just for me, but for all the citizens. And I was only aware here when I was doing the investigation tonight of how the bar using 28 could be much higher than the bar where you're doing the cumulative on 12.16 and 34, and how saying that both were the same question could result in a determination that the Constitution was not breached by the nomination, because the second question, my question, would never be answered.